is one of the thought leaders on constitutional law in America. He's on speed dial for CBS, ABC, NBC, BBC, New York Times, Wall Street Journal, Washington Post, Fox News, all of them.
They get the idea.
Yeah. He was part of the 30 under 30 in law and policy for Time Magazine. And for those of you who like playing fantasy football, he's the founder of Fantasy SCOTUS. He's written over 60 law review articles that have been cited over 1,000 times. So we're not exaggerating when we say thought leader. So without further ado, Professor Black.
Thank you so much. It's always a treat to come to UH because you are so close. I have class today at 2 o'clock, right across the highway, and I'll be teaching at the Supreme Court today. So good timing. The Supreme Court is in a bit of a state of settlement. For many years, the court was pretty static. Between 1994 and 2004, the court was the same. After Justice Breyer's confirmation, we had no vacancies. But then in rapid order, things started to change very quickly. In 2005, Justice Sandra Day O'Connor announced that she would step down. And several months later, Chief Justice Rehnquist unexpectedly died. He had been sick for some time, but he didn't think he was going to die, and he passed away very quickly. And that gave George W. Bush two very important decisions to make. Initially, he had nominated John Roberts to fill Sandra Day O'Connor's seat. But then after Rehnquist died, Bush pulled a switcheroo and put Roberts in the Chief Justice seat. But then he had to appoint someone to fill Justice O'Connor. And there was a lot of pressure on him to pick a woman, as it were. So his first pick was someone named Harriet Miers. How many of you know the name Harriet Miers? Okay. She's not in the court, as you can tell, because she didn't make it through. Harriet Miers was Bush's lawyer, and she was a practicing lawyer from Dallas, very well regarded, but she had no experience with constitutional law, had never been a judge before, and it just screamed of nepotism that Bush was picking his personal lawyer for the position. So Harriet Miers withdrew, it was a big deal, and then Bush picked a judge from the Third Circuit, Samuel Alito, who was a very well-regarded judge. Okay. The court was then static for a couple of years, but this started pushing the court to the right a bit, in that Justice Alito was more conservative than Justice O'Connor was. She was a bit of a moderate. And it seemed, at least at the time, that Roberts might be more conservative than Rehnquist was. So there was hope springing eternal among conservatives. Fast forward to 2008, President Obama wins the election, and then immediately he gets two vacancies. Again, George Bush had 0 vacancies his first term in office. Had Bush lost re-election, he would have no Supreme Court picks. So in the first go-round, Justice David Souter, who was a H.W. Bush appointee, steps down. And what happens? President Obama nominates Sonia Sotomayor to fill the Souter seat. Again, so this was a Republican nominee who was quite liberal, being replaced by a liberal nominee. So not much of a change in the court's composition. 1 year later, John Paul Stevens, who had been a Ford appointee, also turned out to be quite liberal, was replaced by Justice Elena Kagan, who had been the dean of Harvard Law School and also the Solicitor General of the United States. But again, that left the court more or less where it was, a 5-4 court with Justice Anthony Kennedy sort of in the middle. And he was in the middle. For some time, Justice Kennedy was in the majority of the cases, like 95% of the time. He rarely had to dissent because wherever the court was, that was him. He was the court, as they say. King Louis, I am the state, right? He was the court. But then we fast forward a few years to 2016. Actually, it was Valentine's Day. Never forget it. Justice Scalia went on a hunting trip in West Texas. He went to sleep. He never woke up. He died in his sleep in a ranch in West Texas in February of 2016. This was at the height, the pinnacle of the election season. At the time, Donald Trump had not yet locked up the Republican nomination. But a debate was held that day. I think it was in South Carolina, memory serves, where Trump said, aha, we have this vacancy. I'm going to pick for Scalia's seat Judge Bill Pryor or Judge Dianne Sykes. If you don't know those names, they'd never been to the court, but he picked those names at least at the time. And Trump sort of changed the game by putting out a list, several lists actually, of people he would pick for the Supreme Court. Now, who is not on the list? Neil Gorsuch. Whose name was not on the list, the first list? Brett Kavanaugh. Whose name was not on the list? Amy Coney Barrett. Who did he pick? All people who weren't on the list. So the list didn't actually matter too much. The list kept expanding for people he actually wanted. But Trump, I think, was able to secure the nomination in large part by saying to conservatives, I will pick someone to fill the Scalia seat. And in the Senate Republicans did not give, oh, poor Merrick Garland, I feel bad for him now. They did not give poor Merrick Garland even a hearing or let alone a vote. Against all odds, Trump wins the election. And one of his first acts is to nominate Neil Gorsuch to the Supreme Court in 2017. And again, that is for the Scalia seat. So you replace a conservative with a conservative, which more or less kept the court in the right place. In some regards, Scalia is far better than Gorsuch, but more or less in the same regard. What happened next? In 2018, after much cajoling, Justice Kennedy announces that he would step down. In fact, he didn't give advance notice. On the very last day of the term, I was actually at the court that day. On the very last day of the term, Justice Kennedy goes to the White House after the court and says, Mr. President, here's my letter to resign. So he had no advance notice. In fact, I kind of have a suspicion because I went to court that day. Kennedy's wife walks in, his kids walk in, his grandkids walk in. Oh, I know it's coming. So there were hints this was coming, but it wasn't clear. And then shortly after Kennedy stepped down, President Trump nominated Brett Kavanaugh to fill the seat. Now, Kavanaugh had clerked for Justice Kennedy. He was a very prominent appellate judge in D.C., very well regarded. And at first, Kavanaugh's confirmation hearing went pretty smooth. It didn't seem to be too controversial. But then the allegations came out from Christine Blasey Ford about things that Kavanaugh was alleged to have done when he was in high school many years earlier. And there were more allegations about things he may have done in college, and all these other people started making allegations. Kavanaugh was barely confirmed. He barely got 51 votes. But he didn't need a filibuster. Why? Because for the Gorsuch nomination, the Democrats in the Congress filibustered Gorsuch. And as a result, Republicans nuked the filibuster. So had they not filibustered Gorsuch, which was a waste because he was getting confirmed, Kavanaugh would have never gotten through. So just lay this out. Okay. Now, this arguably shifted the court much more to the right, at least on paper. Kennedy was always this moderate swing vote, but at least Kavanaugh would be this conservative judge, not entirely, but at least push the court to the right a bit. Okay. Things would stay the same for about a year and a half. And then in 2020, we get the COVID pandemic. And then June of 2020 is Trump's final really term in the court. He lost big league. He lost on the census. He lost on his tax returns. He lost almost everything. People say this is the MAGA court. The conservatives keep ruling against the guy. This is not the court you're thinking of, trust me. But then in September of 2020, Justice Ruth Bader Ginsburg passed away. She'd been suffering from cancer for many years, and she passed away somewhat suddenly. This is true. Her dying words were, I don't want Trump to pick my replacement. She told this to NPR. Those are her dying words of a federal judge that she wanted a Republican to not pick a replacement. She died, and she would not get her final words. Within a few days after Ginsburg's death, President Trump nominates Amy Coney Barrett to fill the seat. Now, you know who Justice Barrett is. You probably never heard of Professor Barrett. She was a professor for about 15 years or so. Didn't do too much of note. She'd been an appellate judge by Trump. She was on the Seventh Circuit for about a year and a half or 2 years. And then she was thrust onto the short list before she even decided a case. So the fix was in. It was going to be Amy all along. There was no doubt she was put on the short list before she wrote a single opinion. The fix was in. And it was her. Barrett was rushed through the process. Miraculously, they confirmed her in like a month from start to finish. And she took the oath, I think, the day before, maybe 2 days before the presidential election, in last week in October of 2020. And one of Barrett's first tasks on the court was to decide an election dispute from Pennsylvania about whether the state courts can modify the rules. And Barrett's like, okay, I'm not doing this one. She sat out on it, fine. But just because she wasn't up to speed yet. But indeed, all the election cases that came to the court in 2020 and 2021 all 3 Trump appointees ruled against Trump. They all did. None of the judges ruled in favor of Trump. And again, so this myth that they're trying to get Trump in office, trust me, they would much rather not have Trump in office. It makes their lives much easier. They can sort of do their business, not worry about the insane stuff that's going to be maybe coming down the pike. But that brings us to 2021. And that was a term for the ages. In June of 2022, the court decided 3 issues in the span of a week that truly changed the shape of modern constitutional law. Abortion, guns, and religion, all in the span of about a week. You all know the Dobbs decision, which overruled Roe v. Wade, was 5-4. Chief Justice Roberts couldn't do it. He made up some other standard, but he just could not go along with overruling Roe. New York State Rifle and Pistol versus Bruin, which recognized the right to bear arms outside the home. Justice Thomas wrote a majority saying you have to look to historical practice when deciding what the Second Amendment means. And Coach Kennedy versus Bremerton. This is a case of a football coach who can pray at the 50-yard line in the middle of a game or after the game is over. It was, at least on paper, a speech case, but in the process, the court overruled the Lemon Test. This was a decision about the Establishment Clause that said you can't entangle church and state. Bam, bam, bam. Dobbs, Bruin, Bremerton, one after the other in the span of a few days. It was the most sort of shocking or jolting change in American constitutional law, at least in my lifetime, maybe in any of yours as well. Actually, you're younger than me, so definitely in your lifetimes as well. I'm being a law professor. I get older, you stay the same age. It's a funny part of the job. It's true. When I started, I was 28 years old. Now look at me. But this was a very big shift. And almost immediately after these cases, there were efforts that we need to reform the Supreme Court. We need to expand the Supreme Court. We need to impose term limits in the Supreme Court. We need ethics reform. And let's just be very clear what all this is. These are people who don't like the court's decisions now trying to say, okay, well, the court was great when we were getting stuff we wanted. We got gay marriage was great. We got abortion was great. But whoa, guns, no, no, no. So let's start trying to regulate the court and let's put all these various restrictions on the court. There were never efforts to do these things in the 70s, the 80s. So far, these legislations have not gone anywhere, but both President Biden and Vice President Harris have both said that they would support ethics reform, which is really a way of just recusing conservative justices. Just be very clear what this is say you can't decide these cases if some other body says that you perhaps have a conflict. There are only 9 justices. If one justice recuses, you can't pluck a justice from somewhere else. It's a shorthanded court, and it's one fewer conservative to cast a vote. That's what we're looking at. And that brings us to the term that just finished, the term that began in 2023 and began in 2024. The court is still, without question, conservative, and perhaps is the most conservative court since at least the New Deal, if not longer. But it's not, people like when I say this, it's not quite as bad as some progressives might fear. If you want to see what a true conservative court looks like, go to New Orleans. Look at my beloved Fifth Circuit. The Fifth Circuit writes lots of rulings that keep getting reversed. Not as often as you might think, but they do get reversed quite often. So this is not a MAGA court. I've described it as a 3-3-3 court. And you have this 3 wings of 3. You have the 3 progressives who usually don't break formation. You have Justice Sotomayor, Justice Kagan, and Justice Jackson. They are very powerful progressives. They believe what they believe, and they're not afraid to say it. But they usually vote together, and they sometimes use their vote strategically to fracture off the majority. They're very, very crafty like that. And then you have the 3 conservatives, which is Justice Clarence Thomas, Justice Sam Alito, and usually Justice Gorsuch. I say usually because it's a case involving Indians or gay rights. He seems to go the other way. But for the most part, he's pretty solid for the most part. And then you have the murky middle, as I call it. You have Chief Justice Roberts, a W appointee. You have Justice Kavanaugh, Trump appointee. And you have Justice Barrett, another Trump appointee. In any given case, any one of them will vote against conservatives, maybe 2 of them, maybe 3 of them. They, for sure, are conservative judges. And I think they would mostly say that they're textualists and maybe originalists, depending what time of day it is. But they are concerned about what you might call consequences. They very much worry about the consequences of their decisions. How will they be perceived? what results will flow, right? And I think in many cases, their concerns about the consequences trumps their jurisprudence. They're also concerned about how they're perceived. And not that it's a popularity contest, but I think that these judges really do care that the court's respected as an institution. And they don't want the court to get too far ahead of American popular opinion. Someone told me that Judge Jones was here last week, and she always says, I don't care if people think that me, and she means it. By the way, do you know Judge Jones should be on the Supreme Court? God bless George H.W. Bush. Back in the day, George H.W. Bush had a decision to make. William Brennan, the liberal lion of the court, retired. And who does he pick? Edith Jones or David Souter? Edith Jones or David Souter? This was perhaps the biggest mistake in the entire history of the Bush family. I'll throw Iraq in there, throw no new taxes, throw everything in there. This was a colossal error. But the thing is, I don't think H.W. was that conservative. I don't think he actually knew he was getting with Clarence Thomas. If he did, he wouldn't have picked him. He had no idea. So maybe they cancel out. But we could have had Edith Jones, Supreme Court. Roe v. Wade would have been dead 30 years ago. It'd be a very different country. But anyway, I very much respect Judge Jones. I'm glad she came here to speak to you all. But she doesn't care what people think about her. I think Justice Barrett was elected Professor of the Year. I've never been elected Professor of the Year because I piss off students sometimes. The people who win Professor of the Year are the ones who everyone loves. You love that affection, that adoration. I'm here to teach you, make you guys work hard. I'm never going to get that. And I'm okay with that. My students will say, man, he's a hard professor, but he was good. Okay. So you don't want people who win popularity contests in the Supreme Court because they want to be popular. Popular, right? You want to be popular, right? Sorry. Anyway, two people got that. All right. Wicked of me. Anyway, so the three in the middle in any given case might fracture off. So truly, just to give you some numbers, last year, about a third of the cases were 6-3. 6-3. Okay. How many of those were 6 conservative, 3 liberal? About half. All right. There are many different configurations with different groupings of justices that are not partisan splits. And you want to know what else? But half the cases were unanimous. So the justices don't vote in the sort of partisan fashion that you might expect. All the justices, I truly believe, and I believe this in my heart of hearts, are concerned. They are careful about their craft. They have different philosophies, but they just see the world differently. But they're really trying to get their law correctly. And I think there's too much of an effort to vilify them because people don't like the results. All right. Let me sort of walk through some of the high-profile cases. Again, there were about 60 cases last year. I'll just do a handful of them. First, let's talk about the First Amendment. Let's start there. Murphy against Missouri. This was a case about jawboning. You know what jawboning is? It's not this awful thing, right? It's where a government official calls you and says, hey, it'd be really nice if you do this. And you say, well, if I don't do it, what will happen? Well, nothing will happen to you, but we in the government would really appreciate it if you did this for us. Do you say no to that? Turns out during the pandemic, people in the government would often call Facebook and Twitter and say, you know, people are posting the stuff at vaccines that we just don't like those messages. And, you know, you should really look very carefully about these messages and maybe, you know, think about taking them down. We're not telling you to take it down. Oh, and by the way, all this money we're giving you for different things, these contracts, just a reminder, right? And the question was, did this violate the First Amendment right? The court said no. And this was a case where Justice Alito, Thomas, and Gorsuch were in dissent. So you had 6-3, a liberal majority from Barrett. She said no one was injured. There's no injury. There's no standing. Barrett was a Fed court professor. She sees herself as the standing hawk. And she never gives anyone standing. No one else standing. Get out of court. She doesn't want you to be there. Okay. Next case, Moody versus NetChoice, or also NetChoice v. Paxton, the Texas flavor. Florida and Texas enacted regulations of various social media companies. For example, if you take down someone's post, you have to explain why. You can't block people and so on. The court didn't actually rule if this violates the First Amendment. That'd be too easy. Instead, they said, well, you know, NetChoice brought a facial challenge, trying to as-applied challenge, come back later. But the Kagan majority signaled very strong that this is a violation of free speech, And you had Alito, Thomas, and Gorsuch, hello again, saying, no, this is okay. You're regulating Facebook like a public utility. So again, the 6-3 is not the 6-3 you think it is. A case called NRA versus Vulo. This is with the National Rifle Association. New York basically tried to discourage people from doing business with the NRA, saying, "Oh, don't use their products, their insurance products, because they're bad, right? Don't do business with the NRA." And this was retaliation for the NRA's gun positions. This one was 9-0, reversal of the Second Circuit. Linkey v. Freed. If a government official has a Facebook page, is that public? Is that a public forum? Can a government official delete your post and block you from their Facebook page without violating the First Amendment? The court doesn't actually decide it clearly, but they say, yes, it's probably speech, it's probably public. Go back to lower court and figure it out. Not a very edifying decision. All right. There are various cases on the separation of powers, which I love talking about. SEC versus Jarkisy. You all know you have various administrative agencies. What you may not know is if an agency takes an action against you, they can bring an action in either federal court or what's called in-house. Within their, scare quotes, they're judges. They're not really judges. They're administrative law judges. But there's an upshot. If you get sued in federal court, you can ask for a jury trial under the 7th Amendment. But if you get sued in a administrative proceeding, there's no jury trial. And the Supreme Court actually started earlier. The Fifth Circuit held this violates the 7th Amendment, that you can't deprive someone of a jury trial by having these in-house adjudications. And the Supreme Court affirmed. This was 6-3 conservative. And they said, Chief Justice Roberts said, aha, the 7th Amendment right protects your ability to go to get a hearing before a jury, even if it's administrative. Okay. The next big case, Loper Bright. And don't call it Loper. It's not. It's the name of a company, Loper Bright. That's the name of the case. Loper Bright versus Raimondo. This involves Chevron. You guys learn about Chevron here? Good. Chevron was a case from 1984, 85 about a deference. And the court suggested that if Congress passes a statute that is ambiguous and the government has a reasonable reading, you defer to the government. It's getting darker. That's weird. As you're talking about Chevron, the darkness comes over us, right? Anyway, so the court for, 40 years has suggested that you defer, here comes the light, you defer to ambiguous regulations. You defer to the government's reading of an ambiguous regulation. The Supreme Court more or less stopped applying Chevron about 10 years ago. They just stopped citing it. Lower courts still did, but not the Supreme Court. And there was this massive effort to overrule Chevron once and for all. Chief Justice Roberts finally found a case he was willing to overrule. It's not abortion. It's not affirmative action. It's Chevron. Good for you, Johnny boy. So he overrules Chevron. This, again, is a 6-3 decision. Kagan, Sotomayor, and Jackson are in dissent. And it basically says, all right, courts, you have to decide sort of de novo the best reading of the statute, not by deferring to the agency. And it gets dark again. Whatever. Okay. Brand new building, right? Nothing works. All right. Next post is Corner Post versus Board of Governors. This involves statutes of limitations. Right? I tell my students SOL. If you don't follow it, you are SOL. Right? When do you sue to challenge a regulation? So there's a statute of limitation of, how many years is it? How many years is it? Let's say 5 years, whatever the rules. I'm blanking on the number. Let's say 5 years. Is it 5 years from the regulation's issued, or 5 years from when you're injured by the regulation? Because let's say there's some regulation that was passed 20 years ago, and then you open up a new business tomorrow and it injures you. Can you sue now for regulation that was passed many years ago? The court says yes, that the injury accrues, and that's when the clock starts ticking for the statute of limitation. This is a actually significant case. When you combine Loper Bright with Corner Post, it means you can challenge some old regulations under the new standard. This 1-2 punch, I think, is going to just be extremely significant for the future. Next up, Trump v. United States. Right? Oh, sorry, I jumped ahead. I'll do Trump in a bit. Garland v. Cargill. Let's do some more admin stuff. The bump stock. Okay, what's a bump stock? A bump stock is a sort of accessory you put on your shoulder and you attach it to a rifle. And when you pull the trigger once, the rifle goes back and forward and hits your finger. And it keeps going back and forward, keeps hitting your finger, resulting in many bullets coming out. This was used in a mass killing in Las Vegas some years ago. And actually, it was President Trump that decided to ban bump stocks through regulation. And he basically said, bump stocks are like a machine gun, because machine guns really can't be sold in commerce. The Supreme Court, affirming the Fifth Circuit, said, no, that is not permissible. That there's only a single function of the trigger. Each time your finger goes like this, that is not a machine gun. So this ruling, they don't have a bump stock here. I've had students who've had them. Maybe it's South Texas, we keep these. But didn't have too much of an impact. Okay. Speaking of guns, we'll talk about the Second Amendment. I mentioned the Bruen case, which held that you have a right to bear arms at the home. Then we have, what about the rights of former felons or people who committed crimes in the past? Enter Zacky Rahimi, not a good dude. Zacky Rahimi was a domestic abuser. He beat up his girlfriend. He shot at people. He shot up a Whataburger, right? I always love when they do this stuff. It's like, what's a Whataburger? He shot up a Whataburger. This man should not have been on the street. He should have been in jail. But for whatever reason, he was never put in jail. Instead, a judge issues a DVRO, a domestic violence restraining order. This is an order that says you cannot go near your girlfriend, and also, by the way, you can't have a gun. So under federal law, he was disqualified from having a firearm. Okay. Of course, he had a firearm. He started shooting people again. That's who he is. So he was charged with being a felon in possession and violating, not felon. He was charged with being in possession of a firearm during having this restraining order against him. After Bruen, the Fifth Circuit said, no, you can't do this, right? If you're convicted of a crime, they can take away your gun, but you can't take away the gun based solely on an ex parte restraining order. Now, I think the Fifth Circuit accurately read Bruen. You may not like Bruen, and you may not like the idea of a person with a gun who's crazy shooting his girlfriend, but the law is the law. What did the Supreme Court do? The Supreme Court reversed itself. They didn't tell you this, but that's what they did. They changed the precedent. The Supreme Court changed Bruen, and Chief Justice Roberts said, well, there's really no record of taking people's guns away when they have this restraining order, but it's close enough, right? If someone's dangerous, you can take away their gun. This undermines Bruen in significant ways. Poor Justice Thomas was a lone dissenter. It was an 8-1 vote. And he's saying, what happened? I was here 2 years ago, and we just made this ruling, and now we're backing away from it. So Thomas, I think, is exactly correct. Whenever you see the Fifth Circuit's reversed, look carefully if the Supreme Court changed their standard. Because the Fifth Circuit followed the precedent faithfully in this case. In fact, there was a Fifth Circuit panel from just a week ago with Judge Jones and Judge Ho, I think Judge Wilson with the third, where they said, aha, we got Rahimi back. Okay, Rahimi, you go back to jail. But the Supreme Court changed the standard. So it's not Josh saying this, it's Judge Jones and Judge Ho and Judge Wilson saying this. Don't believe me, believe them. All right, abortion. Let's talk about abortion for a moment. Mifepristone is a drug that's used to induce abortions. The FDA has approved it for use many years ago, and they've changed rules over the years, so now you can get it without even seeing a doctor, and it can be done through telemedicine. Okay. A group called the Alliance for Hippocratic Medicine, which is a group of doctors, challenged this in Amarillo Federal Court, and they argue that they are injured by this regulation. No, not they have to take mifepristone, but they argue that as doctors, they might have to deal with the complications of women taking mifepristone down the road. Okay. The district court ruled in their favor. The Fifth Circuit ruled in their favor. This is a case where the Supreme Court reversed by 9-0, even Justice Thomas. I'll explain the Thomas one in a moment. Again, this is Justice Kavanaugh saying that there's no standing, that there's no injury from doctors to challenge the mifepristone. Now, what's significant here is, again, the government changed the case on appeal. There's something called conscience protection. That is, imagine that you're the only doctor in a hospital, and a woman comes in and says, I need an abortion performed. Do you have to do it? This was an open question for many years. And the lower courts, the government said, yeah, you have to do the abortion. Before the Supreme Court, they changed their minds. They changed the answer. No, we don't have to do this. So again, the Fifth Circuit got reversed in this case, but the government changed the case. So the reversal counts, I think, are somewhat arbitrary. Another abortion case called Moyle versus United States from Idaho, Moyle. Okay, what is Moyle about? Idaho has a law similar to Texas that bans abortion. Okay. Federal law says that if you're in a hospital that accepts Medicaid, you are required to perform sustaining treatment. That's if a person walks in and requires emergency treatment, you have to sustain them. Okay, what if a woman walks in and says, I have a condition, it's bothering me, I need an abortion? There's a conflict between federal and state law. Federal law would seem to prevail. The court ruled, again, it was a very weird ruling, didn't even work on the merits, that there's not really a conflict here because, again, under conscience laws, you're not required to perform the abortion. So, again, the way the case was litigated in the lower court, yes, you got to do the abortion, and the government changed it in appeal. So there's so much stagecraft when you see a reversal, what's actually going on behind the hood. All right, let's talk about the Eighth Amendment for a few moments. Grants passed Oregon versus Johnson. This case involves homeless people, right? And where can they sleep? A city in Oregon basically banned camping. And they said, if you camp, we will fine you. And this wasn't about, Boy Scouts and, people, hanging out in nature. It's about homeless people who were just sleeping on parks and benches in different places. Now, the homeless people said, wait a minute, this violates the Eighth Amendment. I have nowhere to go. I don't have a home. You are fining me for something that I can't avoid. My mere existence of laying down on the ground and putting a blanket on is a crime, right? I can't go to sleep without going to jail, right? I need to sleep to live. I can't live without sleeping. And I think it's, as an emotional argument, it's very compelling. But the court says 6-3, sorry, the Eighth Amendment says nothing at all about this. So they lost. This was an unusual case where even like Governor of California Newsom is saying, yes, Supreme Court, please help us deal with this homeless situation. So this was not one where the left and right lined up neatly. Let's talk about, I'll do Trump for a bit, and I'll wrap a mess, take some questions. Trump. We have lots of cases involving former President Trump. Trust me, if I'll put money in this. If a election case goes to the Supreme Court, Trump will rule against, the conservatives will rule against Trump. Trust me, they don't want him. They want someone else. Because they can rule against Harris and things will be normal, right? But Trump just is hair on fire every day. As it were. So the first case is one I did a lot of work on called Trump versus Anderson. This involves Section 3 of the 14th Amendment. Hold on, what's Section 3? Well, you all know Section 1 is you have due process, equal protection. And you have Section 5, which is, in the enforcement power. Pop quiz. Anyone know what Section 2 is about? Section 4. Section 2 is about voting. Section 4 is about debt. Section 3 is about insurrection. Okay. Section 3 provides that certain people took an oath to the Constitution and then engaged in insurrection are disqualified from holding certain offices. Okay, well, this seemed to be very important after the Civil War because everyone agreed the Civil War was an insurrection. And yet a lot of people who were in government, in the Union, went down south and joined the Confederacy. They went rebel, right? So there wasn't much of a doubt over, who was subject to disqualification back in the 1860s. Everyone kind of knew who these people were. But January 6th happened. And Trump gave a speech, as he will tell you. I just gave a speech. I just showed up, right? He gave a speech. And after he gave the speech, people started marching on the Capitol. And a lot of them broke into the Capitol. And they stopped the vote counting process for the joint session of Congress. A lot of people thought that was an insurrection, that Trump engaged in it. And there was a sustained effort to disqualify Trump from the ballot. And in fairness, I did a lot of work on this case. I thought he was not disqualified. The district court actually in Colorado adopted my arguments, which was very useful. But the Supreme Court of Colorado did not agree with me. And they actually said that Trump must be kicked off the ballot. So the case went to the Supreme Court. The result was a unanimous reversal that Trump will stay on the ballot. But the court split 6-3 and maybe really 5-4 over what grounds would be there. But the bottom line is that the states do not have the power to take Trump off the ballot by themselves. Beyond that, the court fractured. The majority suggested that only Congress can do it, and the dissenters said, well, we won't decide who else can do it, even though it's obvious if it's not the states, it has to be Congress, perhaps. The next Trump case involves immunity. Now, you learn about in criminal law qualified immunity, right? That if you're a police officer and you engage in some act and it hurts someone, you're only liable if there's some sort of clearly established law. So there's immunity for police. Judges have immunity too. Good luck suing a judge for his rulings. You can't do it. They have absolute immunity. Prosecutors have absolute immunity. Good luck. You can't sue a prosecutor. You can't do it. The Supreme Court held in a case called Nixon v. Fitzgerald, 1983, that the president has civil immunity, that you can't sue the president for stuff he did while in office, because that would, chill his actions and discourage him. But the court never had to decide the issue of presidential criminal immunity. Why? Because no president ever committed a crime. Well, that's actually not even true. True story. President Grant was actually given a speeding ticket for being in a horse and buggy going too fast. I swear that's true. It's true. But no president has ever been convicted, charged with a felony while in office. I'll make it that simple. I'm sure presidents have committed felonies; they just weren't caught. Anyway, so before the issue of whether Trump actually broke the law on January 6th, you have the question of immunity. The lower court held that there's really no immunity. The Court of Appeals had kind of a wishy decision. It goes to the Supreme Court. Here we have 6-3 conservative. This was Chief Justice Roberts' crowning achievement, probably the most important decision he will write in a long time. And he said, that there are these 3 zones. Think of Youngstown, right? So there's some areas that are core presidential powers. You cannot criminalize those. And there's some areas that are obviously personal, non-official acts. You can't criminalize those. But you have this sort of mushy middle, kind of like Roberts himself, where it's not really clear what time of day it is. And for those, it's a case-by-case basis, and we'll figure out later what to do. People flipped out with his decision. I don't think it was that bad. I think the court had to do something with the lower court. I mean, they decided to indict Trump, or they're going to have to do something. And they said, we'll just have some areas where it's presumptively protected, but lower court decide in the first instance. So this goes back down to the lower court. So that was, last term. I'll give a bit of a preview of our next term. We have a case about ghost guns, Garland v. Vanderstock. I'm actually one of the attorneys in that case. This is about the ability to make your own firearms at home using various gun kits. Another case about restriction on transgender treatment for minors. This is called Scrimetti. This is part of the new Title IX regulations. We have another Texas case. Texas tried to restrict minors from accessing child pornography. Sorry, let's say again. Texas tried to restrict minors from accessing pornography, things that are harmful to minors. And so that's a First Amendment issue. A case I'm actually teaching in class today, medical marijuana versus Horn. This is actually kind of sad. A truck driver got into a car accident, had a lot of injuries, and he got this CBD oil, which would help him relieve his pain. And the CBD said, no THC. And they took it, and of course, he tested positive for THC. So now he's trying to sue under RICO for damages. There are other issues that are probably coming up involving abortion and religion and guns, but I will stop there. I've been talking for almost 40 minutes. Thank you all for your attention. I welcome your questions. Yes. Yes. Very good question. So the question we couldn't hear it was about state red flag laws. These laws take various forms, but the upshot is, I know someone, I think they may be a risk of harming themselves or others, and they ask a judge for an order, it might even be ex parte, to take the person's guns away. I think these are very, very problematic, not only under the Second Amendment, but also under due process. Rahimi was only litigated as a Second Amendment case. So I think the primary way to challenge the ex parte orders would be the due process clause. But I think Rahimi signals that the court doesn't want dangerous people having guns. Think of the teenager in Georgia who, everyone was saying, this guy's dangerous, and like he brought an AR-15 to school in his backpack, like no one stopped him. So even when you have all these sort of red flags in place, you're still not going to stop someone hell-bent on causing, a mayhem. A good question. Yes, sir.
So, wondering, administrative law.
Don't call it Loper, it's Loper Bright. Thank you.
So there are 2 cases, or at least one right now, one that could be. It's the Title IX litigation on the HHS deciding we get to define what it is, and then there's vaccine litigation could be pending in the sense that the CDC and the FDA define what vaccine meant in 2021 to improve things that Wednesday.
Yeah.
The reason they did that is any medication prevents treatment vaccine category changes in protection. So when an administrative agency decides to redefine the word that they're supposed to regulate, how has that process been? How does that process look moving forward?
Yeah. Good. Right. So the question, if you couldn't hear it, was post Loper Bright, how does it work when an agency tries to redefine a term? And this was actually one of the biggest problems with Chevron, is that every 4 years or 4 to 8 years, when the new administration, they would clarify or reinterpret really old regulations. And under another case called Brand X, you actually had to provide deference to those changes of opinions, right? In other words, they were allowed to change every 4 to 8 years, which created this sort of this whiplash, this ping pong effect where, Bush says one thing on net neutrality, Obama says the opposite, Trump says the opposite, Biden says the opposite, right? And every 4 to 8 years, it keeps switching back and forth. I think that becomes harder because now it's a question for the courts to decide what is the best meaning of the statute. And that best meaning of the statute won't change if a new administration comes to town. So I think there's going to be a period of sort of settlement where Biden is in office now for another, 3 months or so. We'll see what happens in the election. But the next administration will really get to decide the settled meaning of a lot of these statutes and put the argument forward. So for the next 4 years will be very important for admin. Good question. Yes, sir. Sure. Right. So I think the fallout from Chevron and Loper Bright in particular is that whichever president comes to office in 4 years will not get deference. Right. I mean, ironically, they say that, repealing Loper Bright is pro-Trump or pro-Biden. It's really neither. It's pro-court. Right. It says the courts get to decide the best reading of the statute, not the agency. So if Trump does, in fact, win in 3 months or in a couple months, his administration will be worse off for it because they can't rely on the Chevron deference. If Biden wins re-election, or if Harris wins election, then her administration will not get the benefit of Chevron. One of the other wrinkles, to answer your question a little further, is even if the Supreme Court says don't give deference, what's going to actually stop lower courts from giving deference? They don't call it that. Say, well, we're going to use our own best reading of the statute, and we agree with the government. So they might do the same thing under a different label. Thank you for the question. What else? Yes, sir. Yes, yeah, Matt. Go ahead. Yeah, good.
This is a little off topic from what we talked last day, but with vaccine law, I was wondering how Jacobson in Massachusetts, it has a very narrow grouping, and it doesn't really explain how things are the way they are today. And I read your article.
You read my article. Oh my God, she read my article. I love it. Okay, go on.
It was the best precedent in the vaccine paper by far. But
Thank you.
I'm still having trouble connecting all those dots. So since you're here today, I was wondering if you could just briefly answer that.
Oh boy, sure.
I know it's a huge question.
That's a big question. So, Jacobson versus Massachusetts is probably the most important case you've never heard of. It was a case, was it 1905, involving a smallpox vaccine. Now, vaccines in 1905 were not what they were today. They could kill you. They actually were quite dangerous. And generally, people had smallpox, they were likely not to have it again because you had an immunity that was natural. Cambridge, Massachusetts had a law that said if you did not get vaccinated, you had to pay a small fine. Was it $5 or $10? Yeah, it's basically a parking ticket, the equivalent of a parking ticket. They said if you don't get vaccinated, you have to pay a parking ticket fee, $5, whatever it was. And the Supreme Court said that law was constitutional. The decision by itself wasn't that outrageous, but it's sort of been interpreted in very broad ways, so that the government can actually make you get a vaccine. And it's say that you don't have control of your own body. Jacobson is inconsistent with basically all common law from the 20th century, right? All these cases about bodily autonomy and liberty and so on. Jacobson was a Lochner era case, right? It was a very different time. So I wrote this paper during the COVID pandemic. I wrote it very quickly because I was home all the time. Nowhere else to go. And I discussed why there's this myth about this case. The courts have shown no interest in revisiting Jacobson. There have been a couple cert petitions asking to overrule it. Nothing from the court. The closest was Justice Gorsuch, who got in trouble for not wearing a mask on the bench with Justice Sotomayor. But Gorsuch has signaled that Jacobson was wrong, but I think he's going to leave it there. And I hope that we never talk about vaccine mandates ever again. But look, I was here, you were here a couple of years ago. I didn't see any of this coming. Then all of a sudden we have all this case law about lockdowns and COVID. Yes, we don't talk about it anymore. But you ever notice that? It was like the biggest thing in the world. We just ignore it. Have you seen any movies about the pandemic? Any books? Like, it's as if it just had never happened. Right? With wars, there are movies about it, right? You talk about it, we just ignore it. Any statues for the death, people that were lost for the vaccine, who died from the pandemic, watch it, right? We just pretend it never happened. Well, reminders when you go to the airport, oh, people have masks on, I guess, still. But just, anyway, but maybe we'll talk about it later. I can't do it in 2 minutes, Justice.
Okay.
Yeah, good.
There was another case, I think it happened, it was decided the last week of the term. It was about 18 U.S.C. 1512, which is the public disorder. It's like the charge used on most of the January 6th amendments.
I didn't talk about Fisher, yeah.
Fisher, yeah. Would you briefly talk about Fisher?
Yeah, it was on my list. I skipped it, but this is a third Trump case. It's not really been a Trump case. So obstruction, right? What actually was the crime that was occurring on January 6th? Well, there were some crimes that are obvious. Trespassing, okay, that's obvious, right? If you assaulted a federal officer, that's obvious. If you destroyed property, smashed a window, okay, that's a crime. But the government also brought various obstruction charges against people. And obstruction of what? An official proceeding, right? What was the official proceeding? That you obstructed, the counting of the votes, right? This was a complicated case, but the upshot is the court, by 6-3 vote with Justice Jackson, the majority actually, narrowed the scope of the statute, which might make it harder to actually convict Trump of these things, which I don't think will ever matter because he's fighting on immunity. But the court sort of narrowly construed what obstruction meant. That's what I don't have time for today. I'll take me too much time. Okay, what other questions we have? Yes, sir.
Last one,
Hail
Hail Mary.
Mary.
Any chance of like open polls in overturning something like that?
Oh, can we overturn Wickard? I think it's very unlikely. Even Justice Scalia was willing to go there, only Justice Thomas. Justice Gorsuch might have an appetite, but I don't think he will. Barrett loves stare decisis way too much, so it's not going to happen. She won't even overrule Smith. My goodness, look at her. So I think we have no shot overruling Wickard.
Thank you, everybody.
Thank you all so much.
Thank you, Professor.
Thank you.